regrettable and an aberration on Kenya's constitutional order, not the norm. My Lord, I am thankful for the time. My learned colleague, Mr. Ogada.
Thank you. How many people are yet to speak?
For these applications, there are two. I was with Mr. Ogada and Mr. Ndegwa. They have heard you when you talked about 30 minutes. They'll try to divide the time amongst themselves.
My Lord, I'm also...
You have given you other time.
For you, you are told you are
My Lord, I was saying that
later.
also interested parties in the application and we would require 15 minutes.
We will reach you.
Wait for us.
Your time has not come.
Your Lordship, the presiding judge, Your Lordship, Justice Mrima, Your Ladyship, Justice Mugambi, I will be brief. A famous quotation says that while the legislature is the will of the majority, the court must always remain the conscience of society. That is the spirit of the Constitution 2010, and that spirit has been reiterated time and again by this court. Mine is two tasks before this court today. I will be going through a panoramic vista of the authorities before this court, and finally, I will go through the political question doctrine, something that has quite excited the other side, and to debunk the myth that the political question doctrine in any way applies in the context of the Constitution 2010. We are dealing here with an application for the preservation of conservatory orders, and insofar as the application in petition E15 is concerned in terms of prayer D and E, extension of those conservatory orders to cover the entirety of the proceedings pending judgment and determination. My senior colleagues have gone through the essence and the reasons why conservatory orders ought to be granted. Mine is just to buttress this, that I will add this court to look at the decision in David Ndii and others. That was a 5-judge bench decision led by Professor Justice Joel Ngugi as he was then. And in paragraph 29 of their ruling, that is dated 26th February 2024, and in that decision, quoting a decision from the Supreme Court of Appeal in Nigeria, United Cement Company versus Dangote Industries, the court says that conservatory orders are prophylactic. They are intended to save the substratum of petitions. And as been ably demonstrated by my colleagues before me, we will sit at monumental oddity, the perfect storm in the teacup, when we allow certain processes to happen, including the swearing in of Professor Kithure Kindiki, who argued with me the BBI decision, that if his swearing in should go on, then these petitions will be rendered academic. That certainly should not be the legacy of this court. This court, in the context ably articulated by my learned senior, Mwalimu Elisha Ongoya. We have provided a couple of cases in our submissions to buttress what my learned senior, Mr. Kibe Mungai, has articulated in terms of the tests in Getirao Munya. We have the case of Kang'ethe Kinyanjui, the Norlak case. These have been attached to a list of authorities. They express, in terms of fine legal distillation, what will mean by an arguable case. And in terms of that infamous term that was bandied here before, the term nugatory, it has been judicially defined. You look at what the the Court of Appeal in Kangede, Kinyanjui, and No Lake define nugatory to mean. In terms of public interest, we will invite this Honorable Court to look at the case of Ethics and Anti-Corruption Commission versus Professor Tom Ojienda and associates and others, whereby the Supreme Court says that an additional limb to be examined is public interest. And we have labored in our submissions, Your Lordship, the presiding judge, to itemize 7 items of why the Constitution, as was articulated by my learned senior Ongoya, why the Constitution qualifies as the highest embodiment of public interest. We are here to argue for a conservatory order to issue as a prophylactic device to save the Constitution. That's our constant north. It should not be forgotten. Still on the question of public interest, my good friends representing the first petitioner have in their bundle of authorities 2 cases. The Court of Appeal decision in Matindi versus the Attorney General, 2023 EKLR, the CAS case, famously called. And then we have the Ojo case, Ojo versus Agriculture and Food Authority and 8 others, 2024. I am reliably told that that was argued by my good friend, Professor Tom Ojienda, my senator, Queen's College alumni. And in that case, this is what the court said, in a nutshell, that we need to keep out a nominee from public office so as to protect the Constitution, the integrity of the Constitution. Keep out that nominee. Let them not go into office. That is what we have been arguing. Ojo, Matindi, CS. Oh, I argued CS, by the way. Elisha Ngoya went through certain positions in law as contained in Justice Mrima's decision, Justice Mwongo's decision, your own decision. Those decisions are not idle. They are not mere words in English. They bear legal consequences by the virtue of the doctrine of judicial comity, that when a court declares itself on a position of law, and in the context of these particular petitions, we are dealing with collegiate decisions. Those decisions enjoy protection by virtue of the doctrine of judicial comity. Lord Justice Newberger, in an authority that we have supplied, the case of Willis and Joyce, 2016. This is the 2 2018 appeal cases. We've provided that. Lord Newberger says this, that so far as the High Court is concerned, puisne judges are not technically bound by the decisions of their peers, but they should generally follow a decision of a court of coordinate jurisdiction unless there is a powerful reason for not doing so. That creates an honest presiding judge, Justice Mrima, Justice Mugambi, that the other side has to satisfy you that those courts, including yourself, made an error in making those determinations for you to depart from the same. Elisha Ngoya painted a beautiful picture of how odd that will be. We have also provided the case from the Supreme Court of the Parliamentary Service Commission versus Martin Nyaga Wambora. The court there examined decision-making and vacation of the same in the context of a collegiate court. The test has been given there by the Supreme Court. And what the Supreme Court says is that if this court might be tempted to reverse what has been made in terms of decision by a collegiate court, then the error has to be substantial. It has to be demonstrated. It does not simply amount to a question of mere allegation, huffing and puffing. It has to be shown demonstrably to the satisfaction of this court. I want to move quickly to the question of political question doctrine. My good friend, my brother, Mr. Gumbo, has spent a lot of ink, black and white, submitting on this. And he submitted to this court the authority of Baker versus Carr. To him and those on that side who submit in that line of thinking, we say this, that the political question is an American constitutional emanation. It is a function of separation of powers unique to the American constitutional context. That's number one. In the context of the Republic of Kenya, that doctrine has been morphed and understood to mean justiciability and non-justiciability. And in our context, it has been understood to yield to notions such as ripeness, mootness. And this was done by no other than His Eminent Grace, the Lord Justice Mrema, in the case of Anthony Miano and others, was the Attorney General, 2020 EKLR. Thirdly, the political question focuses on limitation by courts, on the court restraining itself from dealing with matters within the responsibility of the political arms of government. Now, in terms of the US context, and I have said that Mr. Gumbo has submitted on this case, and we wish to respond to him. This is what they did not tell you in terms of Baker versus Carr. Baker versus Carr, 1962, lays down 6 factors that can be used in identifying what a political question is. So the political question within the American context is not a general rule of application. It is applicable, yes, but within certain parameters. And the context in which that political doctrine question principle can be used is where, number one, there is lack of a judicially discoverable and manageable standards for resolving the dispute. In other words, the judiciary does not have the wherewithal to deal with that question. Number two, the impossibility of deciding the dispute without being to the detriment of a political policy determination that has been made. Number three, the impossibility of the court undertaking such independent resolution without expressing a lack of respect to the branches of government, the political branches. Number four, the unusual need for unquestioning adherence to a political decision already made. Number five, the potential embarrassment from multifarious pronouncements by various departments on the same question. And sixth, a textually demonstrable commitment to the issue of a coordinate political department. Those are the 6 circumstances according to Baker versus Carr. So the question, Your Lordship, Presiding Judge, what will be the usefulness of this doctrine in Kenya? The Constitution of the Republic of Kenya, David D. and others, the Constitution of Kenya has an internal theory. As Elisha Ngoya articulated, and as was articulated in BBI, the Constitution is a transformative Constitution, such that our tenor, our tone in terms of Constitution is radically different from the American. From the text of our Constitution, this is what the Court of Appeal in the BBI decision said at paragraph 139 and at paragraph 144. At paragraph 139, the Court of Appeal said that the Superior Court, being this court, by virtue of Article 22.1, 23.1, and 258.1 of the Constitution, had jurisdiction to complete and incomplete breaches of the Constitution. Your Ladyship, Your Lordships, the substratum in the BBI case was a bill that was stopped in its track before signature. That is important in terms of this context. At paragraph 144, this is what the Court of Appeal says, that when matters involve a threat to breach constitutional rights, justiciability requirements are satisfied and hence the court is allotted with jurisdiction. The court is seized with jurisdiction when a breach of the Constitution happens. From the constitutional text, plain reading, Article 4.1 read with Article 4.2, together with Article 1, provide an interface between law and politics. I repeat, 4.1, 4.2, as read with Article 1, provide an interface between law and politics. The requisite of power ultima, sovereignty in the people, and the requirement by the Constitution that government and governance must be in accordance with the Constitution, Article 2.1, our supremacy clause, ensures that politics are subordinated to the rule of law and constitutionalism. Article 3, the preservation clause. Everybody is enjoined to defend the Constitution. And that provision has normative significance in establishing a legal and moral commitment to uphold and protect, defend the Constitution. Article 3.2, an attempt to establish government, including appointments, otherwise than in conformity with the Constitution, is unlawful and unconstitutional. Article 2, sub-article 2, no person may claim or exercise state authority except as provided under the Constitution. In conclusion, Your Lordships, Your Ladyship, in an old story, and it's probably even true, when the authors of the American Constitution declared after months of work in Philadelphia that they had finally reached consensus, a lady by the name Mrs. Powell shouted a question to the revered Benjamin Franklin, an American statesman, who was then 81 years old. And this is what Mrs. Powell told Benjamin Franklin. Dr. Franklin, what have you given to us? A monarchy or a republic? And this is what Your Lordship, Your Ladyship, Dr. Franklin answered the lady. A republic, if you can keep it. The judiciary must stand as the unyielding guardian of the Constitution, the protector of the Republic, for when it falls, the pillars of justice and democracy begin to crumble. I submit. Thank you.
Thank you. Bananjeru,
Yes, my lady, my lords.
how are you?
I'm well, my lords.
You have 10 minutes.
My lord, I'll try to do the best within the time allocated.
All right.
My lord, my lady, my lords, permit me to join issues with the earlier submissions made by my learned friends